Hi, everyone. My name is Sarah Schickman, and I'm a managing partner here at Lingia Law. We're a healthcare law firm, and we work with lots of med spas and IV hydration practices. And this video with my colleagues is about how to start a medical spa or an IV hydration business in Texas. We're not big fans of those very scary and confusing videos from lawyers, so we wanted to make a video that's easy to understand and goes over some of the basics about starting this kind of business and how to do it easily and compliantly. So before we begin, I'll let my colleagues introduce themselves. So Nick, why don't you go ahead first?
Okay, Sarah, thanks. Hi, everyone. My name's Nick Schaefer. I'm an associate attorney here at Lingia and a member of the Texas Bar. I'm hopeful today that we can provide some practical information that will help highlight the legal issues entrepreneurs face in this space, and some of the things that are particular to starting a healthcare business in Texas.
Yes. So I am Allison Powell, and I'm also one of the associate attorneys at Lingia. So it's great to get to talk to all of you that are watching and explain some of the intricacies of Texas law. I'm also licensed in Texas, so I'm excited to talk to you.
All right, awesome. So let's dive right into the exciting world of med spa regulations in Texas. So first of all, what is a medical spa and what makes a business a medical spa? Like, what if I call my business coffee shop and I only offer IV hydration? Will that make me a medical spa?
It might make you a pretty unsuccessful IV hydration business, but it will make you a medical spa. This is really dependent on the procedures that are being offered. So IV hydration, for example, is considered a medical procedure in Texas and does have to be performed at a medical practice. That's where we get into spa versus medical spa.
Got it. So what's the difference between a spa and a medical spa?
Well, a medical spa is kind of like a hybrid between a spa and a medical clinic. So you're offering medical procedures, which is where the legal stuff gets a little bit more complicated. But you're also offering more traditional spa procedures or treatments, like facials or massage or different things like that. So it's kind of this hybrid between medical and a traditional spa. But when you are adding that medical component, you are subjecting yourself to all this complex web of medical laws, medical business targeted laws, regulations, licensure requirements, malpractice liability. Whereas traditional spas are more focused on, just general business and general liability law. You have this really complex layer that kind of sits on top of it that's all healthcare specific.
Exactly. Like Nick is saying, with a medical spa, you're dealing with treatments that require trained medical professions and professionals and a lot more regulations. So the legal hoops to jump through are a little bit higher.
Got it. So this brings us to one of the most important topics and something that a lot of people starting a healthcare business for the first time may not know about. And that's the prohibition on the corporate practice of medicine, which is alive and well in Texas. So Allison, can you tell us a little bit about what that is?
Sure. So the prohibition on the corporate practice of medicine, otherwise known as CPOM or CPOM, is essentially a public policy that has been adopted into law that ownership and control of a medical practice should be held only by a physician. The reason for this is that there is a belief that profits should be prioritized over patient health, and if an outside party has control over the decision making of a medical doctor, and their rights to prioritize and make the safety of their patients their priority, then you're going to start putting patient safety at risk. However, because of this prohibition, other participants in the space who want to open a business that offers medical services, such as medical spas, which we're discussing today, are limited to ownership by a physician. Texas isn't alone in this prohibition, and there are several other states in the US that are like this as well. And so there's just a little bit of strategic thinking that needs to go into opening one of these practices.
Got it. So let's say I'm a registered nurse or I'm a business person or I'm a lawyer and I want to open up a medical spa or an IV hydration business in Texas. What does this CPOM mean for me?
So, as a nurse or a business person, there are still ways for you to participate in a medical practice, even though you can't do so through direct ownership. Instead, you can own and operate what's known as a management company or a management services organization or an MSO. There's 1,000 different names, which essentially is a company that helps manage a medical practice that's owned by a licensed physician. So an MSO can own the majority of assets, such as the brand name, the equipment, the space, and then they're able to license those assets to the medical practice and then also assist in running the administrative side of the practice. The key to these structures is that the physician needs to maintain the decision-making and control over the medical aspects of the business.
Okay, so my next question is to my colleague, Nick. So let's say I'm a nurse and I want to open this business. Do I have to partner with a doctor to have control, or how does that work?
As an attorney, I wouldn't say that you have to partner with the doctor because that implies that you're sharing in the profits and losses of the business. What I'd instead say is that you're going to be contracting with a doctor and their medical entity, and that's going to be so that you can create a compliant MSO, MSA structure that Allison was talking about. What will happen is you'll own 100% of your management company. You'll own the assets of that business, including your trademarks and your name, the equipment, the space lease will be through your management company. And then you're going to contract with the doctor's professional entity, the medical entity, for them to provide the medical services.
Got it. Okay. And so then once my lawyer set up this structure for me, what government boards do I have to worry about that oversee this kind of practice in Texas?
Well, it's a lot of government boards. You have the Texas Medical Board, the State Nursing Board, the Pharmacy Board, maybe the Cosmetology Board if you're offering services that are considered cosmetology. All of these boards have rulemaking and disciplinary authority over their licensees, which also includes entities. So every type of healthcare entity and practitioner, from big hospital chains down to little one-room med spas, are subject to the rules and the power of these boards. Texas also has civil and criminal laws that target fraud and abuse in the healthcare space. These laws look into the ownership and compensation structures that you've set up between yourself and physicians, or your business and the physician's business, to see if there's anything improper in the way that you're paying them, if you're trying to induce physicians to refer more business to your med spa, or if you're trying to get marketers to use unscrupulous tactics, or what the medical board considers unscrupulous tactics, then you can be subject to these laws that are healthcare specific that you might not have dealt with when you're operating or owning another type of business.
Right. And these regulations also cover things like licensure for medical professionals, standards of care, the amount of supervision that's required, and then also business registration. And if you don't follow the rules, you can face things like fines, penalties, or even having your business shut down. You also are subject to the registration requirements of the Secretary of State and the tax registration requirements of the Texas Comptroller. So there's a lot of parties that are at play here.
And are there also zoning and local ordinances you have to worry about?
Absolutely. We have the federal level of government down to state and then down to individual municipalities. You need to look into where you can set up your med spa, what kind of signage you can use, and whether the property that you're looking at leasing is zoned for medical use. You don't want to run into trouble with your local government when you're trying to start a successful business.
Wow. Well, thanks guys for breaking all that down. That's a lot of things that people have to comply with. Can you tell us a little bit about the licensure requirements? So Now we talked about the ownership and how that has to be structured, but talk about what kind of licenses the professionals working in the medical spa have to have.
So licensure is going to depend on what procedures you're offering. At the end of the day, every medical practice has to have a physician involved. So you're going to have physicians that require licensure by the Texas Medical Board. And then you may have other types of licensees, such as RNs or NPs, that will need licenses from their respective board. Physician assistants will be under the Texas Medical Board. And all of these boards are working together a lot of times to make sure that there's proper supervision and documentation of supervision for all the levels of licenses that you may have working in your practice.
Right. You don't want to mess around with licensing. It's crucial for patient safety and staying on the right side of the law. It's also so important for maintaining the livelihoods of your employees and yourself if you're licensed with one of these agencies.
Definitely. And so when it comes to hiring medical staff, what legal considerations should be on people's radar?
So right along those lines, first and foremost, you want to do a license check and make sure that they're qualified and licensed to do the job. And then you want to hire them just like you would hire any professional that you're looking at. You want to check their references. You want to speak to their past employers. If they have a long work history, you want to have them provide you with any training documents on the specific procedures that you're going to be having them do. Or if you're going to be training them, discuss that training with them because everyone needs to be competent. And so do your due diligence to make sure that they're competent to do the job that you're hiring them for. And then to make sure that there's no, or to, I guess you can never make sure completely, but to kind of lower the risk that there's going to be an issue, ensure that there are clear employment contracts that outline the roles and responsibilities and liabilities of the party to avoid any misunderstandings down the line. You want to like clear policies in place so that there's no fights breaking out amongst like you with your employer, and then also like among the staff that you hire, like people are getting paid differently and things like that.
Good point, definitely. And I think the HR environment is definitely changing and becoming more contentious. So having this paperwork in place, no matter where your business is, becomes really important. So the next thing we wanted to talk about is advertising and marketing. How can we make sure that we're staying compliant with regulations in Texas?
The simplest thing to do is to keep it truthful and transparent. Make sure your ads are accurately representing your services. Steer clear of any misleading claims. You can't overstate a treatment's effectiveness or advertise benefits or results that aren't based in reality. It's all about honesty and integrity, but it's also about knowing the law. Texas has specific laws for medical advertising that affect everything from posting before and after photos to patient testimonials. So you do want to check with a lawyer about your advertisement's compliance with Texas law as well as federal law from the FTC.
Exactly. Because these are medical practices, you've got to follow HIPAA regulations when it comes to marketing and advertising. So kind of like what Nick was saying, don't share patient information publicly without ensuring that you have the patient sign consent. So that includes things like before and after photos on your website or social media, even if you're blurring out the patient's faces and think they're not identifiable. Also, if you're responding to like a negative review, we've seen that even get people in trouble because they'll confirm that the treatment or they'll volunteer the treatment that the patient got and kind of give some type of identifying information about the patient. And well, then they've just violated that patient's HIPAA right. So patient privacy is really important when you're in a medical setting.
What about contracts with vendors and suppliers, like when buying equipment?
You want to make sure that everything is spelled out in black and white, what services are being given, what the payments are. If there is a dispute, is there a form of dispute resolution that's required? It will save you a lot of headaches later on to have all of these things worked out from the get-go.
Yeah, it's also in these contracts important to protect your intellectual property. So you need to protect your trademarks, your proprietary treatment protocols, because these are the assets that represent all the hard work you've put into distinguishing your business from your competitors.
All right, so we talked about structuring risks, we talked about advertising, we talked about licensing of professionals in your medical spa. Let's talk about how we can minimize some of these risks. Besides hiring a great law firm, what are some other things to minimize liability?
So some of the risks that you're going to face in this space are malpractice claims, injuries, possible fines for noncompliance. I mean, there's not to be scary, but there's a large list that could come up. So you really want to mitigate them to the best that you can. And one of the best ways to do that is to have the right insurance in place. Also, you want to make sure that you have a good consent form from patients and that you're maintaining top-notch standards of care. So we recommend that all medical spas have both general and professional liability insurance at the very bare minimum. There's other insurances you could get, but we want to see at least those two. And then make sure that you get a documented signed consent for every procedure that the patient is receiving, and that consent is up to date. You should work with an attorney or other like professionals in this space and make sure that you're really aware of what the regulations are to ensure that you are following the minimum standards of care that are set by the state. And then I would even take it a step further and make sure that you're following the standards of care recommended by the industry, because a lot of times these are even higher than the bare minimum that the state requires. And you always want to make sure that you're in best practices with industry standards as well as state standards.
Yeah, that's great advice. All those things definitely help and mitigate risk. And another thing you can do to document the fact that you're maintaining the proper standard of care is have written protocols that your staff reads and agrees to, policies and procedures, and employment handbooks. It also, like we talked about before, really helps to avoid misunderstandings, to have everything spelled out. Like, what time are people supposed to come to work? How are people supposed to dress? How are people supposed to do Botox? Are people allowed to do filler under the eyes in your practice? All these kind of things should be documented somewhere and signed and agreed to by your staff. So let's talk about some more specific legal considerations about procedures.
Yeah, so you want to make sure when you're offering different procedures and different treatments that the practitioners who are providing the treatments are properly licensed and qualified for the services they're providing. You don't want to run into trouble with practitioners, whether it be RNs or estheticians or NPs, performing services that are outside of their scope of practice. And one of the reasons that it's so important to talk to an attorney and really do your research on this issue is because it can vary between treatments, what is in a certain license's scope of practice. So it's not just a one-size-fits-all solution to making sure people are properly licensed. It is treatment specific and it needs to be addressed at the beginning before you're providing the treatment. For example, one common area of liability that we see and a big compliance risk is when registered nurses are doing the good faith exams. So this is the initial patient assessment where you are determining whether the particular treatment is suitable for a particular patient. This exam needs to be done by either an MP, a PA, or an MD, but we see over and over registered nurses performing this service and finding out that that isn't in compliance when they get an email from the medical board or the nursing board saying that they're under investigation. Another thing that you want to be on the lookout for is providing treatments that are maybe not safe or are prohibited by the state or the federal government. Medical spas, are often kind of on the cutting edge of providing these new aesthetic treatments, but you want to make sure if something's not FDA approved, that it is considered safe enough to perform on your patients.
Yes, and then you want to stay on top of the documentation for that. So if you're doing something that's not FDA approved, really consider whether it's something you should be doing. And then if you decide to proceed with it, make sure that you have a really, really robust consent, that the patient is aware that it's something that is not FDA approved, and there may be more safety considerations. You don't want to get caught operating without the proper paperwork or out-of-date paperwork. Another example of this is NPs in Texas need to have a written collaborative agreement with their supervising physician, and they need to have documented quality control meetings with that physician. So it's not just getting these things whenever you start initially, but it's making sure these things stay up to date and that you're renewing them annually. The physician and the NP are regularly meeting to see if anything needs to be changed or updated. And like Nick mentioned, each patient is getting that signed consent, and that consent is not signed 2 years ago, and there's been some drastic change and something new that consent really should have included to still be accurate for the patient.
Well, this is a lot of stuff to keep in mind, definitely. Thank you both for the insights. So one last question. How can someone stay updated on changes and regulations in Texas? How can we help them?
A really good way to stay ahead of regulations and changes in the law is to check out our blog, which is on our website. We're always researching new developments, and our attorneys are monitoring legislative trends in multiple states to kind of not only see when a law changes, but try to be able to predict which way rulemaking or lawmaking is going to break and how it might affect your business. You know, the medical spa industry is rapidly growing, and the healthcare industry is always changing. You need someone advising you who's knowledgeable and dedicated to representing your interests. As attorneys, we do have a duty of loyalty to you through our attorney-client relationship. One thing that we see over and over again in the healthcare space is entrepreneurs and even sometimes non-healthcare attorneys treating the startup of a healthcare business the same as a non-healthcare business. If you've had success as an entrepreneur outside of healthcare, you're ahead of the game. You have firsthand knowledge and experience with startups. However, healthcare has this overlapping web of laws and regulations and case law at multiple jurisdictional levels that offer an extra layer of complexity to compliantly starting your business. So it's so important for the future health and success of your business that you talk to a healthcare attorney up front. And if you feel like you're running a business right now that's not compliant, go ahead and get in touch with a healthcare attorney as soon as possible to see if you are running compliantly or if there's any easy changes we can make to make your business more legally compliant and healthier moving forward.
Exactly. Don't be afraid to ask for help if you need it. Compliance is crucial, but it doesn't have to be overwhelming. Bring in experts like a good healthcare attorney, an accountant, consultants, a marketing professional. A big strength is recognizing what your weaknesses are and bringing in a team that can fill in those gaps. I know there are often budget considerations for this, and it can be daunting to have to pay for all of this as a startup. But non-compliance really is so much more expensive in the long run than compliance from the get-go, or a medical spa that doesn't have any patients because your marketing isn't up to standard.
Thanks, guys. These are definitely wise words. Thanks for sharing your expertise and taking the time to do this video. Hopefully a lot of our clients and prospective clients and just people looking into starting this kind of business will find it helpful. And I appreciate your time. And if you guys have any questions to follow up with us, you could always email us at team@lingealaw.com, and we'll put our contact information at the end of this video too. But thanks, everyone.
Thank you.
Thanks, guys.